Good morning, everyone, and welcome to this webinar this morning on the local government pension schemes for employers in England and Wales. We're at 10 o'clock, so we'll get going. I'm Alistair Russell-Smith, and I lead the charity and not-for-profit pensions practice at Spence and Partners, and I'm chairing the webinar this morning. Great time to be talking about LGPS at the moment. There's lots going on. It's mentioned in the Mansion House reforms. We're going to be looking at some asset consolidation in local government pension schemes. Of course, we've got the 2025 valuations in England and Wales coming up. But actually, the main topic we want to talk about today is the strong funding position of local government pension schemes and what that means for exit credits for employers. I'm delighted to be joined today in the webinar by Michael Hayles and Ed Curtis from Burges Salmon. So Michael and Ed are both lawyers, and they work a lot in the public sector on local government pension schemes. And I'm also joined by my colleague Sean Campbell, who works with myself in the Spence charity and not-for-profit pensions practice. We've got about 40 minutes of content that we will run you through this morning, which will be covering the items you can see on screen there now. So we're going to start by just reminding ourselves what the position is with exit credits and the discretion that funds have over those, how cessation bases are evolving, and then importantly, we'll move on to a range of different case studies that are going to cover quite a wide range of different types of employer in LGPS. You'll see that there's a Q&A box, so if you've got any questions as you go along, do use that box. We'll try to get to them as we go, or we'll have some time at the end, or failing that, we'll come back to you after the webinar. Right, so let's get going. Sean, firstly, can you just remind us what is it that triggers an exit for an employer in LGPS?
Yeah, thanks, Alistair, and morning, everyone. So to set the scene for the webinar and give a bit of background to the current environment. So as illustrated on screen, funding levels can be extremely volatile depending on how financial markets move. Over the last couple of years, we have seen favourable improvements in funding levels, such that funding levels on a cessation or an exit basis are at their highest in quite some time. For a number of organisations we have supported through the exit process recently, the value of their liabilities on an exit basis have been lower than their share of the fund's assets and has resulted in an exit credit rather than being faced with an unfavourable exit deficit as we have seen in the past. So what is it that triggers an exit? Cessation is generally triggered when the last active member leaves LGPS pensionable service. So one way in which this can happen, organisations can trigger an exit by moving LGPS employees to another pension scheme for future pension saving, so the members' past service benefits remain within LGPS, crystallising the current strong position such that an exit credit may be payable, which we'll come on to later in the presentation. There's the potential for some legal issues around this, which we'll touch on also. A second way that an exit can be triggered is more naturally when an organisation continues to participate in an exit is automatically triggered when the last active LGPS employee leaves or retires. This is relevant for closed bodies, so no active members are being put in the LGPS scheme. Funding positions at the point of exit are uncertain, and there is the risk that the position could be worse in the future. We've had experience of clients in the past being unaware of this and automatically triggering an exit at unfavourable times, so it's worth being aware of your situation, your admission agreement, your employee profile, etc. There are other ways in which an exit can be triggered, which we'll touch briefly on throughout the presentation, but these are the kind of main two scenarios that we'll be considering.
Great, thanks, Sean. And I mean, you alluded to it as you were talking there, but obviously there's some legal considerations here. Ed, are you able to just expand on those?
Yeah, sure, Alistair. So we would suggest that employers undertake some degree of legal due diligence at the outset when thinking about potentially exiting, and this is essentially to identify what needs to happen legally to allow the exit and whether there are any particular hurdles that need to be overcome. And in particular, it's important that employers understand the basis for their participation in the LGPS. So some employers, such as academy trusts and higher education institutions, are actually legally obliged under the regulations to participate in the LGPS. So exits for these sorts of employers are less likely, but still actually possible. So, for example, in restructuring scenarios, and we're going to touch on that a little bit later on in the webinar. But other types of employers, such as housing associations, charities, outsourcing contractors, they're all most likely to be participating under admission agreements, and for them, they will have much more scope to actively trigger an exit. Therefore, for these type of employers, the first thing to consider really is the provisions of the provisions of the admission agreement, because these may well be relevant to any proposed exit. Secondly, for those employers who have inherited staff historically from the public sector, there may be specific contractual requirements to provide ongoing LGPS participation. So these need to be considered. For example, there could be transfer agreements between a local authority and the employer who's thinking of exiting. And these agreements may place obligations around ongoing pension provision. And these agreements can be quite old, but still active and applicable. So this is often relevant, for instance, with housing associations, where there will be historic transfer agreements governing the terms of the original housing stock and staff transfer. Also, if the employer is a contractor, there'll be an outsourcing contract that will need to be considered, and that's likely to be quite specific around LGPS pension protection. Finally, there's always going to be the individual employment contracts to consider, which are likely to include some form of pension rights and potentially obligations around consultation on pension changes.
Okay, thanks, Ed. Quite a few different legal documents there to keep on top of. Let's just then move on to exit credit. So we've talked about what triggers an exit. Sean, what's the position with exit credits in England and Wales, and how's that evolved over the last 5 years or so?
Yeah, so on screen we have a very simple example which we'll use throughout the various case studies we run through, where assets are 10 million for this example organisation and liabilities on a cessation or exit basis are 7 million. So there is a 7 million. There's a 3 million surplus on an exit basis. So prior to 2018, no exit credits were payable. In 2018, the concept of exit credits was initially introduced, and it was the case where if the employer chose to exit the respective fund, they would have received that the surplus 3 million as an exit credit payment. In 2020, this was changed such that the payment of any exit credits became the discretion of the fund, and this was applied retrospectively back to all exits from 2018.
Okay, great. Thank you, Sean. Okay, so you've made the point that since 2020 and applied retrospectively, it's a discretion on the fund whether to pay an exit credit. It's the case that the fund does need to think about a range of different considerations when setting that policy and making that discretionary decision. Michael, what are those different considerations they need to think about?
Okay, thanks, Alistair. So this slide sets out the different factors which administering authorities are required to consider when determining whether to pay a surplus out of the fund, so whether or not to pay an exit credit. And these considerations are set out within the Local Government Pension Scheme Regulations 2013. So taking each of these in turn, so firstly, consideration needs to be given to what's the extent of the surplus. So this is a key factor, but within this, there'll be questions as to how marginal is the surplus, and also how prudent are the assumptions used to calculate the surplus. So I think what this is probably driving at is how confident are we that the surplus is real, is genuine, and also has been calculated on a robust basis. So what's the extent of the surplus? The second factor, which is going to be important in many cases, is what were the level of the employer contributions. So this is likely to be highly relevant to consideration, for example, whether an employer might get out more than they actually paid in. So perhaps capping an exit credit at the level of the contributions paid in by an employer might be a logical position to take for a fund. Consideration may also be given to, in particular, the extent to which an employer has been on risk. So, for example, in an outsourcing situation where an employer has in effect paid no contributions, perhaps because it's passed all those through to back to the letting authority, or perhaps where there's been capped contributions, a fund may consider that it's reasonable that they don't receive surplus because essentially they've had no risk on the deficit. Thirdly, funds are legally obliged to consider, but not necessarily to follow, representations made by the employer that's leaving. Representations can also be made by the funder or owner of an emission body. So, for example, as the flip side to our previous point, if an employer has held all of the risk in relation to their participation in the LGPS and has paid significant deficit repair contributions, it may be legitimate for an employer to expect a surplus payment, which it could argue, for example, is a return of deficit contributions which turned out in the end not to be required. Now, finally, the fourth factor is any other relevant factor. So this is very broad, but in simple terms, what we think this means is that administering authorities should consider relevant factors and disregard irrelevant factors when making a decision. Ultimately, it should be a reasonable and defensible decision which the fund makes. So relevant factors will include those already discussed, but also potentially future running costs for the scheme linked to the liability of the withdrawing employer. An example of an irrelevant factor could be where an employer is in dispute with an administering authority outside of the pension context. So, for example, if there's a planning dispute between those bodies, to give one example.
Great, thanks, Michael. And apologies for flicking the screen on inadvertently there. I was just trying to pick up a question that had come in, so let's perhaps take that now. When should an employer make a representation? So is it before they've exited or after they've exited?
Yeah, I mean, our suggestion in practice would be that if an employer is planning to leave and there's potentially a surplus and the withdrawing employer considers that there are reasons why it should be paid the surplus, then our suggestion is that it engages with the fund well ahead of time to understand what the position is. Strictly speaking, these obligations to consider representations from the employer are only triggered on exit, so after the event. But as I say, our recommendation is engagement ahead of time.
Great. Okay. Thank you, Michael. Let's move on. So we've now understood the considerations that the fund needs to go through when exercising that discretion. Ed, what have we actually sort of seen in practice in England and Wales in terms of how funds are making policy decisions?
Yeah, so I suppose the first thing to say is that so since the discretion around exit credits was introduced in 2020, we've seen more and more administering authorities of LGPS funds developing written policies around the payment of exit credits. And these policies, perhaps unsurprisingly, often tend to focus on circumstances where funds will not pay out exit credits. So, for example, as said on the slide, where an employer has not been on funding risk because another employer, for example, in the fund, has contractually taken on that risk. Or we've also seen policies that preclude exit credits where participation in the LGPS commenced prior to May 2018, which is when exit credits were first introduced. However, in our view, the funds really need to be kind of very careful in the way that they apply these sorts of blanket policies, because it's clear that in all cases, discretion does need to be exercised, and funds should not blindly or rigidly follow blanket policies around kind of not paying out exit credits without first considering other factors relevant to a particular case. And helpfully, this approach has been confirmed in a High Court judgment in 2021, which considered the exit credit legislation. And the judge in that case made 4 helpful comments on the exercise of the discretion. And just to touch on these briefly, so they were firstly that there is an obligation on LGPS funds to make a rational and fair application of the legislation, giving the words of the legislation their clear meaning. So this really means that the legislation can't be twisted to fit a particular rigid policy position, for example, such as non-payment in all cases where an admission began before 2018. Secondly, LGPS funds, when exercising discretion, should have regard to all the relevant factors of which they are aware. And the judge noted that the regulations do not make any single factor conclusive. So funds will need to consider exit credits in the round and on a case-by-case basis, as Michael's just been discussing. Thirdly, as the regulations don't give primacy to a single factor, the weight given to the different factors will always depend on the circumstances of the individual case. Therefore, there will not necessarily be one factor or set of facts that trumps everything else in all cases. And this is really another reason why it's very difficult for funds to lawfully justify a blanket policy. And finally, regard should always be had to the fact that government introduced legislation that provided for the provision of exit credits. So albeit it's now a very kind of wide discretion of the funds, the government policy position is clearly that there can be circumstances where exit credits should be paid, and funds really need to sort of take that in consideration when they're kind of looking at their policies and applying the substance of their policies.
Yeah, that seems a really important point, doesn't it, Ed? That just because something's written in a policy doesn't mean an employer should sort of give up at that stage. These need to be taken as individual decisions, case by case.
Yeah, exactly.
Great. Okay, and Sean, just sort of moving on to the items 2 and 3 on the slide here. What have we been seeing on our side?
Yeah, so a couple of adjustments that we've been seeing applied to refunds in England and Wales, as Michael has kind of alluded to already, are capping the level of any refund or credit at the level of contributions that employer has paid into the fund, and also deducting off the expected future administration and running costs from that refund payment as well. So this is acting to reduce the value of the credit payments. What we've also started to see in some funds is the hardening of the exit basis in a range of different ways, including the use of cessation corridors and risk-based calculations. So if we move on a slide, we've pulled together an illustrative example of these approaches to hopefully make it easier to follow and understand. So historically, for cessation basis, these have been based on a gilts-based approach where the discount rate has been in line with gilt yields, as shown in the left-hand column on screen with a liability value of 10 million. So when gilt yields are low, this placed a high value on the liabilities, resulting in higher exit debts. Over the last couple of years, we have seen a sharp rise in interest rates, resulting in materially lower liabilities being calculated on a gilts basis, reducing the value of exit debts and in some cases resulting in an exit credit. Funds have started to change their approach to calculating cessation basis to try and mitigate risk. The funds may be in surplus now, but this may not be the case in the future, which they're trying to take account of in their alternative approaches to calculating cessation positions. One approach we're seeing a shift towards is funds using risk-based calculations, as illustrated by the middle 2 columns on screen. They are looking to see what level of funds they need to set aside to give a 90% or 95% chance of sufficient funds being in place over the next Y number of years. A couple of key things to point out here. Generally speaking, this results in a higher liability than a gilts-based approach, so higher exit debts, lower exit credits, as illustrated on screen with the liabilities of between 12 and 14 million compared to 10 million on a gilts basis. The liabilities are also very sensitive to the confidence interval that is used. So as mentioned on the slide, moving from 95% to 90% could take over 10% off the liabilities and vice versa. So if you were 100% funded on the cessation basis using 90%, then if the fund decides to move to 95%, this could wipe out any exit credit you may have received. The final column on the right-hand side is an illustration of the cessation corridor approach. This is an evolution of risk-based where a funding corridor is being set. So if the funding level is higher than the lower end and less than the top end of the corridor, so i.e. the kind of darker pink section at the top of the bar in the right-hand column, no debt will be paid, but also no credit will be paid. You need to have a funding level in excess of the high end of the corridor before any exit credit would be paid. So in this example that we are showing, a low end of approximately 9 million and a higher end just over 12 million. So to receive any exit credit, you would need assets in excess of 12 million. This approach is good if you're underfunded, as it could result in no exit debt or a lower exit debt being payable. The downside is it's just harder to get an exit credit. Different funds use different actuaries, and the results are heavily reliant on the underlying assumptions. Different actuaries will use different assumptions in the calculation, so 95% probability of success in one fund is likely to not be the same across all the different funds.
Thanks, Sean. Let's just take a question as well, because you've talked here obviously about the hardening of these cessation bases, but despite that, is it still a good time to be exiting LGPS in terms of funding positions?
Yeah, so with the high interest rate environment, and even with this hardening of the exit basis, liabilities in a lot of cases are much lower now than they have been for quite some time, which is resulting in these exit credits or much lower exit debts. As we've touched on, there's no guarantee that an exit credit would be paid if it existed, but there is the chance to remove the risk associated with your pension scheme for no or minimal cost. Although you may not benefit from actually receiving a cash payment on exit, your exit credit could be used to fund, for example, purchase of additional pension in your LGPS pension scheme or fund early retirement for those close to retirement age, which may make it a more kind of attractive offer for your employees and help moving them out of LGPS into another pension arrangement.
Yeah, I'd agree with you there, Sean. It's I mean the bases are hardening, aren't they? But the market movements are still bigger than that hardening of the basis, and it particularly, like you say, if you're trying to reduce risk, it's a pretty sensible time to be looking at your options. Okay, let's move on to some case studies. We're going to sort of walk through these. We've got 5 different ones, thinking about the different types of employers in local government pension schemes. So first one here, we've got an outsourcer. So that's an outsource where with the local authority, a contract with the local authority with a pass through on pension costs. So not on risk for changing pension costs. They're just passed back to the authority. Michael, and we've got a surplus position here on exit, 3 million surplus. So possibly a refund. But Michael, what's your take on this situation?
Okay, so so as you say, so under this example, the outsourcing contract provides that pension costs are passed back to the authority. So what that means is, for example, whatever the pension contributions payable and due to the LGPS fund, these were invoiced back to the authority. So essentially, there's been no cost to the outsourcing contractor. So in our view, in this situation, a refund would be very unlikely, as the employer has not been on risk during its participation. And given the pass-through, it will have in effect had no responsibility or no kind of personal responsibility for making employer contributions. So we think a refund's unlikely. But finally, in our example here, as you've said, the surplus exceeds contributions paid. So I think even in a situation where the employer had some risk, you might expect the exit credit to be capped perhaps at the level of the contributions paid, or potentially capped at the level of the deficit repair contributions.
Okay, so that's one end of the spectrum. Let's go to the other end of the spectrum, Sean. So same funding position here, but this time we're talking about a charity or a not-for-profit in the standard employer pool in a fund. They've been participating for well over 10 years. They've been fully on risk for those contributions. They've had to pay significant secondary contributions historically, although those have perhaps turned off more recently. Now looking at a surplus on an exit basis. What's the position here, Sean?
Yeah, so as you've kind of mentioned, this is in complete contrast to the case that Michael's just chatted through. So as you say, the charity or not-for-profit entity is fully on risk. They've been participating in the fund for a number of years and have paid substantial deficit contributions historically. So in this case, we would expect the fund to typically pay out on the exit credit of 3 million illustrated on screen. The charity have been funding the downside risk for a considerable number of years, so they should therefore be able to benefit and receive from the upside credit. And as I touched on earlier, whilst the charity might get an exit credit, it still might be subject to the couple of adjustments we talked about before, so capped at the level of contributions paid and possibly with future running costs deducted from it.
Yeah. Okay. And then let's sort of start moving into maybe the more interesting sort of grayer areas in between. So Michael, we've got a situation here where we've got an employer with a guarantee from the council. We'll come back to what we mean by that. So that means that they've been able to fund their pension scheme on an ongoing basis. So looking at the graphic on the left-hand side, they only really need assets of 6 million, that ongoing liability basis, and they only have to pay an exit debt if they're in deficit on that ongoing basis. But all these recent market moves which we've been talking about mean they're really well funded in surplus on that basis to the tune of 4 million, and even on a sort of standard cessation basis that other employers have a surplus of 2 million. What do we think here, Michael, in terms of a refund and an exit credit? Are we looking at sort of 2 million, 4 million, nothing?
Yeah, so I think, as you say, this is an example where it's less clear cut when compared to the previous two examples. So I think here the important point of detail is going to be actually what is the nature of the guarantee. So how the guarantee might influence the decision will depend upon what the nature of that specific guarantee is. So for example, at one end of the spectrum, you might have a guarantee which only bites on the insolvency of an employer. So essentially it's just residual downside risk protection for the fund. So in that situation, an employer essentially, whilst it's solvent, will remain fully on risk. So in that situation, you can imagine there's a stronger argument that an exit payment should be paid, notwithstanding the existence of a guarantee, because it's again it's been fully on risk and it's essentially on risk until its insolvency. At the other end of the spectrum, you could have a guarantee which is more like a pass-through. So, for example, it might be that a guarantor steps in to make payments or to fund contributions on behalf of an employer, potentially if contributions go above a certain level. So in that situation, it's possibly more like a pass-through arrangement. And again, the employer in that situation might not be fully on risk because they've got the support of the guarantor. And in that situation, it may be less likely that an exit credit is paid. So the nature of the guarantee would need to be scrutinised. I suppose in terms of the amounts which are payable, you can imagine that from a fund's perspective, there might be a preference in both cases to use the kind of middle column as the assessment of whether a surplus exists or not. It might be that if a guarantee's generally been working to keep contributions lower, that might not be a reason that a fund would take the approach to calculate a surplus payment on that ongoing basis. So from my perspective, in probably both situations, you'd expect a level of prudence to come in such that the fund calculate liabilities on a cessation basis.
Yeah, I'd agree with you there, Michael. And like you say, it's all down to the wording of the guarantee, isn't it? But typically, if you are in a world where you might get an exit credit, you're probably looking at 2 million rather than 4 million as an employer.
Yep.
Okay. Let's move on to another type of employer. So academy trusts, Ed, they're scheduled bodies, obviously, so they do have to participate in LGPS, but they still do end up in effectively in exit positions, sometimes through restructurings, for example. So we've used our same case study here. We've got this funding exposure where we're now well funded with the recent market movements. DFE guarantee means that it just needs funding on an ongoing basis. So the 6 million of liabilities there, but standard cessation basis of 8 million. So can you talk us through the restructuring and how that might flow through in terms of LGPS and potential exit credits?
Yeah, sure, Alistair. So yeah, as you mentioned, academy trusts are known as scheduled bodies within the LGPS. So this means that they have to allow their non-teaching staff access to the LGPS. So they can't actively decide to exit and offer a different pension provision. However, exits can happen when there is restructuring of academy trusts. So this might be, for example, where trusts are totally disbanded, which is relatively unusual, or situation which is perhaps slightly less unusual is where one academy trust transfers some or all of its academy schools to another trust. And a transfer of academy schools like this will trigger an exit if it results in an employer trust ceasing to employ active members in a particular LGPS fund. So as shown on the slide here, below the funding levels there on the left, in relation to staff members who transfer with the academy schools to the receiving academy trust, the new employer, the accepted position under the LGPS regulations is that all pension liability in the fund relating to the transferring staff's employment will also transfer to that new employer. So the receiving academy trust takes on all past pension liabilities for those active members who are transferring. However, it's less clear legally what should happen to other pension liabilities associated with the exiting trust. So, for example, liability for deferred and pensioner members. So these are people who have already retired or left service, and so then they're not going to transfer across to the new employer, the receiving academy trust. So in these sort of scenarios in the past, when funding levels within the LGPS were less favourable, we've seen academy trusts being quite anxious not to trigger exit payments in relation to any funding deficit when transferring academy schools. So they've looked to get assurances from the fund that exit payments would not be due, and instead all pension liabilities, including for deferred and pensioners, would pass to the new academy trust and be funded on an ongoing basis, still subject to the Department for Education guarantee. However, now with improved funding within the LGPS, exiting academy trust might want to explore with funds the potential for exit credits, in particular in relation to these pensioner and deferred members. So LGPS funds, may prefer that all assets and liabilities are simply passed on, and that there's no exit credit payable, no surplus to be calculated. But as there's some uncertainty around this, there does seem to be the scope for discussion around the treatment of the surplus, how it would be treated in those circumstances.
Okay, an interesting option potentially there for some academy trusts. Let's move on to our last case study. So post-92 universities, another type of employer we see a lot in LGPS. Again, they're scheduled bodies, so their non-teaching staff have to be in LGPS, and their teaching staff are typically in the teachers' pension scheme. So we've got a situation, but we know this is a sector that's under a lot of financial pressure at the moment. We know that the TPS contribution rates are going up. So Michael, what are you seeing some of the post-92 universities do in terms of sort of managing their LGPS?
Yeah, I mean, I think it's a relatively tricky area. There's certain obligations, as you say, to have certain employees in in the LGPS and TPS separately. It's in principle it's possible, for example, to set up a service company or a different company that's employing staff, which potentially, as it says on the slide, might not participate in the LGPS, or you might give employees the option to join an alternative arrangement. For example, if they want to pay lower contributions, or they want different type of flexibility, or they're at a different stage in their career, some people might favour options. So we are seeing some of those options come in from time to time. In terms of exit scenarios, I suppose an exit scenario could arise, for example, if there has been a service company that actually has employed LGPS employees. And sometimes we see spin-off companies as well. So a particular company's been set up for a particular purpose, maybe a kind of research company. In that situation, sometimes it's been a transfer of employees into that spin-off or subsidiary company, and that participates in the LGPS. So you could see in those relatively discrete scenarios a situation where there could be a future exit, and if there's a future exit, then there's potential for an exit credit or surplus to be paid, as per the examples that we've already discussed. Final point to mention there, which is relevant, and it's kind of similar to the example that Ed gave in relation to academies. So we have seen some situations where there's what's known as a partial cessation. So an employer might be participating in the LGPS and they're funding active, deferred and pension liabilities. It may be possible in some situations to agree that actually you'll terminate your existing admission and then potentially you'll restart the admission, potentially the next day, just in relation to active members. Now, the cessation of the historic admission could give rise to an exit calculation, and there could be a surplus at that point in time. The new admission would just be for active members going forwards. So I suppose that then there's the question as to what happens with the old position. It might be that even if there is a surplus, actually that can be used just to de-risk the deferred and pension liabilities. But actually, even if there's not a surplus paid out in that situation, it might be favourable for the employer, because then in the future, they only have to fund the active members going forwards. But equally, you could have a partial cessation situation like that, where there is a surplus and it could potentially be paid out at that point, notwithstanding that you have a new admission going forwards just for actives. So we've seen a couple of situations where there have been partial cessations, and actually it can potentially be beneficial for all parties, because you can potentially de-risk your deferreds and pensioners, and especially where an employer has been struggling with funding the full population. If it can just concentrate on active members going forwards, then we've seen that to be beneficial as well.
Yeah, again, interesting, and that makes sense. I think, presumably, particularly in this sector at the moment, and the financial constraints it's under. Okay, that's largely it. Just to recap, sort of top tips from us for employers that are in LGPS in England and Wales, and thinking about exiting and exit credits. You can see our 6 top tips on the slide there, just briefly running through those. So do make sure you complete the legal due diligence that Ed talked about at the start. There's quite a few different contracts, commercial admission agreements, transfer agreements, contracts of employment, all potentially having LGPS obligations in them. So make sure you understand what those are. Get clarity from your fund on their exit credit policy, and if you are in surplus, whether or not you'll get an exit credit. You really want that in advance if possible. And as Michael touched on when answering that question, you can make in practice, as an employer, you can make a representation in advance as well to give yourself that certainty. Obviously, get an indicative cessation valuation. These tend to be relatively easy to get from most funds. There may be a small charge, but funding positions have really improved very dramatically since March 22, but even over the course of the last year or so as well. So if you haven't had a funding position for a while, it's worth getting a recent one. We've talked about making the representations, and then also when you're into the exit, if you're progressing to the exit and trying to structure it, and obviously that involves moving affected employees from LGPS to another pension arrangement. There's a whole range of different things you can do there, and some quite interesting win-wins that can be helpful both for the affected employees and for you in terms of initiating that exit. So things like for employees closer to retirement, you might buy them an unreduced early retirement pension with the fund. You might buy them extra deferred pension in the fund. You might look at quite generous DC replacement offers. So there is quite a lot you can do there to, as I say, position this positively with the affected employees. And lastly, do make sure you understand the implementation costs. Obviously, advisors to yourself have costs, but also funds have their own costs and their own advisors' costs, sometimes of which are passed on to you as well. So that's us done. I hope that was useful. Let's just move on to some questions. I'm just going to stop sharing. So one question that's come in, just going back to the point about making a representation, Ed. If the fund has got one, you mentioned some funds have this policy that they won't pay an exit credit for admissions pre-2018. How might you go about sort of challenging that as an employer if you're in that situation?
Yeah, so it's clear from the legislation that the exit credits are have retrospective effects, so they apply to all admissions and participations in the LGPS which cease after May 2018. So merely because the admission has started before that date, that's not a reason in itself to not pay an exit credit, and it would probably be an irrelevant factor taken into consideration by itself. However, there could be relevant factors kind of linked to the start date of the admission. So, for example, for those pre-2018 admissions, maybe an outsourcing, it's very likely that the parties wouldn't have contemplated the possibility of exit credits being paid, and the commercial terms of the outsourcing would be on that basis. So there could be kind of underlying risk sharing there, which would be a relevant factor for funds. So I think it's just if it's there in the policy as a kind of blanket or rigid position, that should really be questioned, because by itself it wouldn't really appear to be a relevant factor. The fund would really have to explain why in a particular case it is in fact relevant.
Yeah, okay. Sean, a question about the sort of process with the calculation of an exit credit. So at what point is that calculation undertaken?
I think there's probably kind of two scenarios that we kind of touched on. So if it's the example where this is kind of a natural occurrence where the last member has retired or died, your last LGPS member has retired or left the scheme, the exit credit calculation will be carried out at that kind of date that they leave the scheme. But if it's a case where you are kind of looking to move your employees out and you're kind of controlling that, you can largely kind of shape when that calculation kind of occurs. You can kind of specify the date that you want it to happen. Now, as you touched on, there's a bit of a process and stuff involved, but yeah, broadly speaking, you can kind of decide when that calculation date is.
Yeah, and it can be an issue, can't it, sometimes for some employers that you don't know for certainty what the exit credit's going to be until after you've pressed the button, because that calculation is done at the date you exit. We have seen a range of approaches being used by different funds there, and some are perhaps more pragmatic than others. So we do see some funds, for example, quoting a cessation estimate in advance that they'll stand by for 90 days. We've seen another fund do something similar, and then take a little bit of a haircut off that surplus to recognise the fact that they are on risk for that 3-month period, whilst the employer effectively has a sort of option on whether or not to trigger that debt. So it is worth talking about that with your fund. There is a different policy in place around some of these funds. Michael, Ed, I don't know if you've seen any other sort of helpful positions taken by funds in that area.
No, not specifically. I think that summaries, backs up what we've seen.
Okay.
So yeah, very similar experience.
I suppose the only thing to add is if the decision around an exit credit. So if a surplus is calculated, the funds then have 6 months in order to make the decision and to communicate that to the exiting employer.
Okay. Another question here, sort of asking review, I guess. Is it fair on employers for exit credits to be calculated on a basis that could be higher than the cost of securing liabilities with an insurance company? Noting this is uncommon in the LGPS. Well, I guess my personal view is it is a challenge for employers when exit debts are or cessation liabilities are calculated on such a prudent basis, and we've, as Sean touched on, we really have seen a cranking up of some of those cessation bases. So to my mind, it doesn't feel necessarily appropriate, and I guess if we want employers to participate in LGPS and LGPS to be growing and thriving, then we need to see a bit of give and take. But would be my personal opinion on the cost of funding pensions and the ability to access excess surplus if there is upside. But I think from the fund perspective, they will tell you that it's very difficult for them to go and actually insure a small portion of their liabilities. So they can't actually do that in practice, and therefore they don't want to calculate a cessation liability on that basis.
Yeah, I think it's a really good question, and in relation to the question, I think it can feel unfair for that a base that's been used that's more prudent perhaps than that an insurance company might use. I suppose in terms of being able to challenge it, I suppose feeling fair is slightly different to whether a fund is acting unreasonably, and there's quite a broad spectrum as to what's reasonable. So I suppose as long as a fund can reasonably justify the basis that it uses, especially bearing in mind, I suppose that a fund has a kind of one-off opportunity to calculate the liabilities, then that's not to say you couldn't challenge, but there might be a difference as to what feels fair, but actually what's reasonable, what's within a reasonable range for a fund.
Yeah, and that's a good point. We have seen some movement from funds on some of their cessation bases. So some movements on the probability of success being used, for example, which, like Sean said, can have quite a material impact. And some are changing bases. And we've got one case where an employer had triggered an exit, but then agreed a deferred that arrangement to stay in the fund for a period of time until a more favourable exit basis came into force and then triggered an exit there, and the fund agreed with that. So we are seeing a little bit of movement from some funds on their cessation bases. All right, let's take one last question. So just a question for Michael or Ed, just around case law. Have we got anything in the pipeline that may impact on exit credits?
I'll go first, and Ed, if you want to jump in on anything. But yeah, so I think as far as we're aware, there's no case law ongoing or in the pipeline. That's not to say that there couldn't be, although if there is case law, you'd expect it to be published and fall into the public domain pretty quickly. And we were involved in the case which Ed referred to earlier in the webinar. That case related to actually the introduction of the discretion that was introduced in the regulations in 2020, and there was a judicial review challenge to whether it was appropriate for the regulations to be brought in on a retrospective basis. Now the government won that case, and so that question has already been determined in the court. And as Ed said, actually that case gave some very helpful, clear guidance as to how the regulations should be interpreted. Now, I wouldn't be surprised if we do get some case law potentially, but from a kind of cost benefit analysis, you'd expect that a case would only be brought due to the cost of bringing a case where there's a substantial surplus that's in dispute. But so I'm not aware of any in the pipeline, but I wouldn't be surprised if we have some coming through. In particular, obviously, where a surplus there's a surplus that exists, but it's not being paid out.
Ed, can you think of any cases that Michael might have missed?
No, I'm not aware of anything coming through. I suppose the only thing to mention is that currently the position with exit credits is a bit different in Scotland and in Northern Ireland as well. But in Scotland, so that currently there isn't a discretion, so they just have to be paid out if there's a surplus. But that's expected to change very shortly to be aligned with the discretionary position in England and Wales. So I mean, it's possible that there could be some litigation that arises as a result of that change, and I suppose how those Scottish funds sort of apply it retrospectively, that might be interesting.
Okay, let's leave it there. I hope everyone's found that helpful. I found it really interesting. I'd just like to thank Michael, Ed, and Sean for their contributions. And clearly, if you've got any follow-up questions or issues you want to talk about, do just get in touch with any of us, and enjoy the rest of your day. Thank you.